Linda was kind enough to not tether us too much on topic and gave us wide berth to speak about whatever issue we thought was most pertinent to our organization. When I was thinking about what you all might like to hear about, I thought the issue that some of you have probably truly grappled with in your day jobs is the conflict between U.S. e-discovery and EU data protection law. We have a very deep conflict between the two, and I'll give you a sense of what this is all about in case you haven't dealt with it. I'd love a show of hands if anybody has actually worked through this issue. No one. Lucky you.
Not yet.
All right. EU data protection law is immensely complicated. So you can imagine that a U.S. corporation that is in the throes of bet the farm litigation that's trying to figure out how to deal with U.S. discovery and deal with the conflict, which is very difficult, between U.S. law and EU law is in for a harrowing time ahead. So let me give you a sense of what this is about. In the U.S., of course, you are required to retain, search for, and produce all documents that are relevant to reasonably foreseeable litigation. In the EU, however, you are restricted from retaining, from collecting, from reviewing, from disclosing, and from transferring outside of Europe documents that could be relevant to litigation if those documents contain personal data. And I'm going to define that term. Before I define that term, though, I'd like to give you a sense of who this affects and tell you a little bit about the background of EU data protection law. John did a great job of giving us a sense of the quote-unquote sectoral approach in the United States, meaning that we regulate privacy through different industry sectors. In Europe, they take a completely different approach called an Omnibus approach to data privacy, and that means that there is a single directive. Well, there are a number of them, but there's a directive that's pan-European. There are a few in this space, so the directives are pan-European, and each of the member states is required to enact laws, data protection and privacy are the same thing, that implement the requirements of the directive. Okay, so there is essentially there's supposed to be a harmonized approach. It's not terribly harmonized, that causes all kinds of problems, but it's meant to be a harmonized approach among the 27 EU member states plus the 3 EEA nations, Liechtenstein, Iceland, and Norway, plus Switzerland. So really 31 countries. The issue that I'm talking about affects US companies that operate globally, affects EU companies that operate in the United States, and very deeply affects service providers that try to operate in the e-discovery space. So a little bit of background. In Europe, privacy is a fundamental human right. Very, very different from what we consider privacy here. In the EU, data has been used to put people to death. In the US, data is used to market people to death. A whole different ballgame. The historical context is truly different. I had heard that the Polish Data Protection Authority, for example, has said that we in the United States cannot understand privacy because we have not seen our neighbor dragged out of his house because of his dossier at 4 a.m, never to return, because of data that had been collected about this individual. So they see data in its historical context, data being used in Nazi Germany, data being used in Eastern Europe, to harm people, to persecute people. Here, whole different historical context. The other problem, of course, is that the directive, the Data Protection Directive, the General Directive on Privacy, was implemented in 1995. 1995 was a time that when you wanted to transfer personal data, you put it onto some electronic media and you took it across the border. An entirely different ballgame now. Data can reside in 62 places at once, and we could be viewing it from 62 places at once, regardless of whether the data is sitting on a server located in the US, in Europe, or in the cloud. Some of you may have heard the term cloud computing. Your data is somewhere, and you don't actually know where it is. Gmail is an example of a cloud. So a little bit about vocabulary. What is personal data in Europe? Personal data is any information that can identify a person. So information about an identified or identifiable person, okay? So it's very, very broadly construed, and it includes name, email address, and it includes things like social security number and passport number. So the spectrum from very general data that we would consider to be public data, not to be given the same level of protection as data that is very sensitive, like social security number. But there is no distinction per se in EU law. So business email, for example, that contains the name of a sender and the name of a recipient, contains personal data to be carefully managed in every context, particularly in the litigation context. In Europe, what they regulate is data processing. The term data processing is also extremely broad and encompasses any operation that is done on data. And that means if you review it, if you store it, if you collect it, if you produce it in litigation, if you move it from place to place, all of that is considered data processing. So you're starting to see where I'm going with this issue. So what is the general rule in the EU? The general rule is that you may process personal data. Remember the broad definition of process and the broad definition of personal data. You can process personal data only if you have a legitimate reason to do so, and if you meet one of the specifically articulated grounds in the Data Protection Directive. So what grounds do we care about here? There are three that I'm going to touch on. The first is consent. An individual, called a data subject in Europe, can consent to the processing of his or her data. Now that is completely impractical in the Ediscovery context, because you're going to be producing email, probably 500,000 or 500 million emails, all of which contain the names of individuals and maybe some other data as well, some other personal data, but certainly the names of individuals. So all of them contain personal data. There's no practical way of getting consent from those individuals to be able to process that data in litigation. The other problem with consent is that employee consent is actually deemed to be a poor basis for processing, because consent is deemed to be forced as between an employer and an employee because of the quote-unquote subordinate relationship of the employee to the employer in Europe. So consent is not considered to be freely given in light of that relationship. So two other legal bases to consider as to how one might process data for purposes of U.S. litigation. The second, so consent is the first. The second is to comply with a legal requirement. You are allowed to process personal data to comply with a legal requirement. The problem is U.S. legal requirements don't count. It's only EU legal requirements that are considered to count in this world. So that legal basis essentially gets thrown out when it's a U.S. requirement that is obliging a company to process data that originated in Europe to comply with U.S. e-discovery obligations. The third basis to consider is that you're allowed to process data if it's necessary to serve the legitimate interests of the data controller, i.e. the owner of the data, the company, but only where those legitimate interests are not overridden by fundamental rights of the data subject. Now, in Europe, data subjects have fundamental rights. They have a right to access all their personal data wherever it's maintained. They have a right to amend that data if it's inaccurate, if it's not timely. So they are given very specific, they have a right to notice as to what's going to happen to their data. They're given very specific rights with respect to their personal data. So in short, you can see that it's not easy to process business records that you need to process in order to comply with U.S. e-discovery requirements. Now, even if you can process that data in Europe, you have a problem transferring it to the U.S. because there's a whole other set of requirements that deals with data transfer. So you need a separate legitimate basis in order to move those records to the United States. What are those legitimate bases? One is consent of the individual, and we talked about how impractical that is when you're moving thousands, millions of records over to the US. Other possibilities. If you are in a country that is considered to have adequate data protection laws in place, you can move data from the EU, which considers itself adequate, to that other country, that third country that is considered to have adequate data protection laws in place. The US is not adequate. Okay, so, you know, we have all those laws that John told us about, zillions and zillions of laws, none of which put us into the position of adequacy vis-a-vis European data protection authorities. So what else can we do? You can sign a set of contracts called model contracts that are, the language is fixed as between the data exporter in Europe and the data importer in the US. You can't negotiate the terms at all. They impose enormously stringent obligations on the data importer in the US, essentially imposing EU data protection requirements on the data importer in the US. And believe me, it's not a hop, skip, and a jump to sign those model contracts. They can't be done overnight if you're actually going to comply with the provisions in those contracts. And the companies, of course, that we represent and sitting on the dais here are responsible companies who don't want to sign a document, the terms of which they can't comply with. A couple of other mechanisms to transfer data. There's a mechanism called the safe harbor. This is a mechanism that was created by the Department of Commerce in conjunction with the European Data Protection Authorities, whereby there was an agreement between those two groups to impose principles on companies who would agree to sign up to the safe harbor, so that those companies would agree to apply European-style data protection protections to the data that comes from the EU, that originates in the EU. There's another mechanism called binding corporate rules that I'll just mention. It's imposing a code of conduct on the company worldwide with respect to personal data. It's a newer concept. It's one that has a lot of problems associated with it, so we don't see very many companies that have binding corporate rules in place to protect personal data. So when you consider each step in the process of complying with e-discovery obligations in the US, you can see that there are obstacles each step of the way. The review of the data is data processing. The collection of the data, data processing. The movement of the data to the United States is a problem, obstacles there. And then, of course, the disclosure of that data once it's in the United States is also a problem. What are the risks? Well, we know what the risks in the U.S. are. Spoliation, all the risks associated with the litigation process and problems with the litigation process. In Europe, the risks are huge because there are criminal sanctions that could potentially attach. So, a company is really between a rock and a hard place. Do you risk criminal liability in the EU, or do you risk losing a bet the farm case in the U.S.? Really tough. What is the practical response? There isn't a really great practical response, but we have often sent experts over to Europe to go through all the documents, to try to cull the documents in Europe, to anonymize them if possible before they're transferred here. We jump through enormous hoops to satisfy the European data protection rules when we're in the throes of litigation on behalf of a client. This really is a seemingly irreconcilable conflict. There's been a lot of discussion around this issue. I think what it really needs is an intergovernmental accommodation. There's virtually no other way of dealing with it. So we hope that there will be continued discussion. I think there will. This is certainly one of the few hot topics that we all talk about. Behavioral advertising is one of the others. So I think we'll be hearing more about this issue, so stay tuned.
Great. Thank you very much.